Supreme Court has ruled in favor of the January 6 rioter who challenged his obstruction charge and hundreds of other defendants. John O'Connor is author of Postgate: How the Washington Post Betrayed Deep Throat, Covered Up Watergate. Joins me now to discuss. John, welcome to the show.
Stacey.
I'm glad you're here because what a interesting past few days it has been with these Supreme Court rulings, starting off with this J6 ruling, which actually has implications for former President Trump, because I believe one of his charges is from this same grouping.
That's right. You have two decisions that affect President Trump. One is the first obstruction one in the Fisher case. And then the second one is in his own criminal proceeding. And there's a very, very interesting opinion that I've just been reading that's fascinating and goes through the history of presidential immunity and what a president can be held liable for and what he can't. So both those things are interesting. In the Fisher case, the fellow apparently had taken a flag and had allegedly hit an officer with the pole. And of course, those facts are in dispute, but let's assume for purposes of argument that he did what he's being charged with. The question is, does that obstruct a proceeding? And the court said, no, that's not obstruction. Now, it may be trespassing, it may be malicious mischief, it may be all sorts of crimes, but it's not obstruction of a proceeding. Obstruction of a proceeding has to do mainly with the evidence that would be put forward. For example, if he destroyed documents that the Congress was going to consider in this thing, he would be obstructing the proceeding by destroying evidence. And that's a good example. If he intimidated a witness or kept a witness from appearing, that probably, although the court didn't say it, I'm assuming that's obstruction also. But the physical act, which sounds like obstructing, he's obstructing this police officer, there's not really obstructing a proceeding. The proceeding can go on whether he hits that officer or not. It's not really designed to stop the proceeding. So that's that decision. And where that bears on Trump is although he's not alleged to have hit somebody, is obstructing a proceeding, for example, giving a fiery speech on the Capitol that causes people, let's assume that caused people to swarm the building. Is that obstruction? I would say no. Even if President Trump told people to swarm the Capitol, I don't think that's obstruction. Now, he didn't say that, but I think the prosecutors are trying to imply that. So there are some elements of what they're charging Trump with that are affected by the Fisher decision, this whole idea of obstructing a proceeding.
So isn't the reason and pardon me, I just want to break in here for a moment. Isn't the reason why they took the extraordinary step of researching this particular charge and adding it to the J6 defendants is that otherwise we're talking about simple trespass, which is a misdemeanor, hitting an officer with a flagpole. If it's your first offense, you're also probably going to have that knocked down to a misdemeanor because there's so much other really serious crime that's going on. So most of these J6 defendants, if they were charged at all, because this was a political kind of event, they would have walked away, as all of the Antifa protesters have done, with either reduced charges or no charges being dismissed. And it wouldn't have really been able to turn this into a political football as they have done with everything having to do with J6.
That's beautifully put, Stacey. I couldn't say it any better. I mean, that's exactly what the situation is, and they're looking because you have crimes, you have recommended minimum sentences and so forth and so on. And if you can get an obstruction conviction, the judge can give the poor guy a couple years. But the other ones, as you say, you should properly not go to jail. It's a first offense. It's a misdemeanor. And that's what it should be in a situation like this. Now, if you cause some serious bodily damage, that's something else. Now you're really getting into more serious stuff. But just merely some sort of tussle with the pole, no. So that's why, and now there are 50 cases on hold because of this, and I think all of their indictments will be dismissed insofar as they're charging obstruction. So there's these 50 obstruction cases waiting in the wings. I think they're all going away.
And will the charge against President Trump go away, particular to the obstruction?
Well, that remains to be seen because there's such a complex analysis here. I think the obstruction decision helps him to a certain degree, but what really helps him is the ruling on immunity. And so it's a very complex three-stage analysis that the court has gone through. There are certain things for which the president is absolutely immune without further question. There are things in which he's presumptively immune. That is, he's immune from anything if prosecuting him would interfere with any legitimate function of the government. And then there are acts that may not be official. If they're unofficial, then it's Katie bar the door. So the main takeaway from Ace Stacy is that the lower court has got to go through this extended analysis, and then it's going to go back up again. I don't think this thing is going to be tried. In other words, it's not going to go to Judge Chutkan and she makes her decisions based upon the Supreme Court and then tries Trump without appeal. No, I think she makes these decisions based on the court's three-step analysis. She makes her decision, and then it goes back up the chain. It goes up to the appellate court and the district circuit, and then up to the Supreme Court. This is a momentous decision that she has to make, and the court basically said, no, we're not going to allow this thing to be tried, at least the way I read it. We're not going to allow it to be tried unless somebody reviews it again.
And that will take longer than the March of 2025 date that we were looking at initially, because I know a couple of months ago when they said that the Supreme Court was taking this case up, they said, okay, so that pushes it back to at least March of 2025. Certainly won't be tried before the election, which was the intention. The whole reason they charged him when they did was to try to get this case before the court and the American people during the election cycle. So that's completely out of the question now.
I would say that the March 25th, March 2025 prediction was optimistic for Judge Chutkan. If she got this opinion back and it did not require further analysis by her, I think she would have taken this case to trial before the election. She was bound and determined to do that. I think a reasonable judge, even without this decision, wouldn't have tried it until March of 25, but I think she would have. If it hadn't been for this decision, I think Judge Chutkan would have had this guy in trial during the election. And Jack Smith, the prosecutor, thought that didn't violate Department of Justice guidelines to try a president right in the middle of an election. And I think Judge Chutkan was going along with it. So Trump has dodged a serious bullet here. If it weren't for this decision, he would be going to trial, I think, by September. So that is, he narrowly escaped here. The prosecution and the judge were gunning for Trump. And yes, if I were judge and this thing went up on appeal, no matter what happened, I would wait until March of 2025. But I don't think Judge Chutkan would have done that.
So I know this is your opinion I'm asking for, but is Judge Chutkan, is she the one who has the time on the bench and legal expertise to even handle a decision in a case like this?
Well, but not conclusively. And I think that's what she, being a district court judge, no matter how brilliant she is, and I think she's a very smart person, she's also very partisan. But this is of such momentous occasion that we shouldn't let the future of the country reside in the opinion of one judge who may or may not be partisan, may or may not be good, may or may not be brilliant. That's why it's got to go back up to the Supreme Court. They really are saying that this is too important. It's the presidential immunity. This is going to be with us for centuries, assuming America can last for centuries. This decision is important, and they're not going to trust it to the lower court to go back and parse the different findings they say have to be made. So that's very good. And she won't be she will be supervised in this. She will make a decision. The appellate court will review it, and then it'll go up to the Supreme Court. The appellate court has already gotten direction from the opinion that's been written. So the appellate court, even though the DC appellate court is fairly liberal, I think the DC Court of Appeals is going to be mine. They're also very bright people there. I mean, they're extremely well-qualified scholars. I think what they would do is probably look over their shoulders at the Supreme Court down the street and say, hey, we better have a decision here that is at least roughly in line with what the Supreme Court has told us. Then it'll go back up to the Supremes.
Well, I like that because it removes the element of partisanship. They can be brilliant people, but partisanship actually decreases your analysis, your analytical ability, your ability to discharge your duty, because it overrules what's right when you are openly partisan, which is why the bench is supposed to be unpartisan. You're not supposed to have those kinds of thoughts and feelings being interjected into these cases. What I love about this is that, on the heels of this breaking story, we have your expertise available to us here at Salem News Channel. So grateful for your time today. And you can get the book wherever books are sold. It's called Postgate: How the Washington Post Betrayed Deep Throat and Covered Up Watergate. Thank you so much, John O'Connor, for coming on the show.
Great talking to you.
All right. Good to have you here. We'll talk again soon. And coming up after this SNC fast break, the Supreme Court has struck down the Chevron deference. This is an Enron era ruling that has been abused by the bureaucracy. I'll tell you what it means to you and so much more here on Salem News Channel. Don't forget to download our app and watch us on free over-the-air television in all of these new markets. You can find out more at snc.tv.